Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about a concept that is used in judiciary is regarding the sealed cover jurisprudence. We are going to discuss this in context of recently in news Media One case, that is a news channel of Kerala, and how the case panned out in the Kerala High Court. So first of all, let us try to understand the context of this particular issue. So actually 2 days before, several MPs, actually 11 MPs from different opposition party, along with 30 eminent personalities of India, have issued a statement. In the statement they have expressed disappointment over the recent verdict of Kerala High Court. The verdict was regarding the Information and Broadcasting Ministry's order that has revoked the broadcasting license of a Malayalam news channel that is known by the name of Media One. This news channel was denied the broadcasting license once because the Ministry of Home Affairs has given an adverse reaction, or we can say has given a kind of expressed their concern regarding the security regions that this channel should not be given the license. So due to this, the court decision, however, not only the decision was people have expressed their disappointment over decision, they also have expressed disappointment over the fact that the way how court has reached its decision, it was solely based on a sealed cover envelope. All the statements or all the information that was given by MHA and Information and Broadcasting Ministry to the High Court were in sealed envelope that was not open to be seen or to be read by any other member apart from the judges, and the content of which were not even shared with the accused party, that is the Media One. So due to this reason, thus eminent personalities have said that this is a bad precedent, and should this kind of approach of dealing with the cases, especially which relates to the freedom of expression, should not do not hold any place in the democratic country like India, and should be scrapped away with. Now let us try to understand in details what do we mean by the term sealed cover and why it is used when it is used. So first of all, basically it means the sealed cover is a term used in the judiciary where information that is given with related to any case by the central government or any state government especially, they are received from the government agencies in a sealed envelope that can only be accessed by judges. That means suppose in this particular case, Media One was one party, other party was the government, Ministry of Home Affairs. So the information was only restricted for the eyes of judges. Even the accused was not given the right to see and look at this information. Overall, this kind of, we can say, practice has been used for a long time period, not only in Supreme Court but also in the lower courts like High Courts and the subordinate courts of India as well. And this raises an issue because the well-known eminent lawyer Prashant Bhushan has said that this kind of use or this kind of method that is utilized by judiciary for reaching on a particular decision is a gross violation of the principle of natural justice. Because as per the principle of natural justice, accused has a right to look at all the information on the basis of which the judgment is being delivered by the judges in that particular case. So let us try to understand, do we have any rules as per the constitution that govern such kind of practices? So the answer is we do not have any specific rules or laws that says that in this particular matter we should have a sealed cover jurisprudence or in other matters we should not have. The judiciary basically uses this concept by two main methods. First, it is governed by the Rule 7 of the Order 13 of the Supreme Court rules itself, and the second source is Section 123 of the Indian Evidence Act that was formulated in 1872. If you look at broadly what these two clauses say, so it basically says that if Chief Justice of any particular court, they have this prerogative right, they have this discretionary power that they can direct certain information to be kept under the sealed cover that is only for the eyes of judiciary and not for the accused or any other parties. Basically, this comes into picture if the information that is received by the judges are of very confidential in nature, whose if it is exposed can threaten the national security and integrity of the country, and if publication of such information in the public is not in the public interest. So in these particular cases, the Chief Justice has the power that they can use this particular prerogative powers of this particular jurisprudence. However, there are certain other grounds also. If we try to understand the whole background or take the example of the cases that has been given by the High Courts and the Supreme Courts in the past. So few grounds are there on basis of which this particular concept has been used by judiciary. So first is as per the Evidence Act, as we have discussed, all the information that is official information, unpublished documents are there that mainly relate to state affairs, such kind of information cannot be divulged for the public information or for at the public forum. Second, such kind of concept can also be used where publication of certain matters or publication of certain information can impede an ongoing investigation, especially if the matters are referred from the police files, and it can actually jeopardize the investigation process. In that case also, the courts, whether it is High Court or Supreme Court, they are allowed actually to use such concept in reaching at the decision, final decisions. Third, also the exception is that if publication of certain information or divulging certain information in the public breaches the right to privacy of any particular individual or any individual, in that case also the courts have power to use this particular concept. So now let us try to understand the sealed cover jurisprudence from the concept by looking at the previous examples where such concepts have been used by the judiciary. So first major example is from year 2018, when we have a very famous case that is related to Rafale deal case. There the government itself was a party, and government taking use or using the Official Secrets Act have said that they cannot divulge all the information for the public, and that is why the government requested that judiciary should actually receive the information in a sealed cover only. And then that time the Justice Ranjan Gogoi of the Supreme Court, he actually allowed the government to present the information in a sealed cover for the decision. Similarly, in 2014 also other important case was the reform case of BCCI, that is Board of Cricket Control in India, and in that case also the BCCI has requested the judges to not allow the matter to become public, because there the names of certain cricketers were mentioned who were allegedly involved in match fixing, and divulging the names of such cricketer could have, before reaching to the final verdict, could have actually created a problem and could have violated the right of privacy of such cricketer. Similarly, in year 2018, in the Bhima Koregaon case, as the matter when it was referred to the court, the investigation was still going on, and that is why the officers were allowed to refer the matters or allowed to present the matters of the whole case to the judiciary in a sealed cover, so that it does not impede the ongoing investigations. Not only that, even the corruption cases like 2G spectrum case, we have coal block allocation cases, and even the case regarding the this development of biopic on Prime Minister Narendra Modi during the time of elections. These all were matters that were referred in sealed cover from the government side. However, these particular concept or these particular practices are not free from criticism. There are several criticism that has been alleged by eminent professionals, eminent jurists, and also the parliamentarians of India. So let us try to understand each by one what are the major criticisms. So first criticism is that this kind of practices actually is threat to the transparency and the accountability of Indian justice system. For example, when any verdict is reached by any judicial court or by any judges, then all the public has right to understand the logic or the rationale behind such a verdict. So if a verdict is reached on the basis of information that is in the sealed cover, public scrutiny will not be available for such verdict, and that will actually threaten the accountability of the whole judiciary. Not only that, it also enlarges the scope of arbitrariness in the court decisions, because obviously, as you discussed, since the justice or the verdict is being reached after the information that is given in sealed cover, so at that time the rationale or the logic behind the decisions that has been taken by the judges will not be available, and also it will be difficult to appeal if the ground of on what ground the lower court judges have given the verdict. If it is not clearly known, then it is difficult to apply on the appeal on the higher courts as well. And also third, it obstructs the process of fair trial and adjudication of accused, because someone is being accused and on what basis he or she is being imprisoned or given penalty, if he or she does not know about the full information, that actually is not fair to him, as it is not in line with the process of fair and trial and adjudication of this accused. And last, it also talks about the privilege of the state, that a state government or not only the central government also many times uses this particular practices, so that they are not able to, so they will not will have to divulge the information because something can threaten the this security of the country. But however, critics says that we have other alternatives such as in-camera hearing, in-camera proceedings, that gives proper we can say that gives proper exception to the cases that is brought to the judiciary by the central government. And for example, if in-camera hearings of the cases is being done, then the matter, whatever matter is there, it will not be published to the general public. And however, the accused party and whoever are parties to the case, at least to them, the matter will be fully divulged. So that is why these four are the main criticism why this particular concept of this secret information that is passed to judiciary is being criticized. Then let us try to understand what has been the stand of Supreme Court on this particular matter. So two cases are there that tells us the stand of Supreme Court. The first important case is P. Gopalakrishnan versus the state of Kerala. In this particular case, the Supreme Court has clearly taken a stand that disclosure of documents to the accused is a constitutionally mandated right. It is the right of accused to demand all the documents on basis of which a verdict in his or her case is being provided, even if the investigation is ongoing and said documents may lead to breakthrough in the investigation. In that case also, the right of accused to get all the information related to his or her case is a constitutional right that is given to him. Apart from that, the second verdict was given by Supreme Court in the INX Media case of 2019, where the former Union Minister was actually denied bail because the matter was referred to the Delhi High Court and the matter was referred in a sealed envelope. So Supreme Court that time had criticized the Delhi High Court's decision for basing its verdict to not grant bail to the former minister solely on the basis of the sealed cover information. And the document submitted was by the Enforcement Directorate in sealed cover. So these two cases clearly tells us the stand of Supreme Court that the right of accused to get the information trumps over any other exception that has been given and on the basis of which the sealed cover jurisprudence is applied. So on the conclusion, what we can understand that sealed cover doctrine is now being used across all the courts in India. The precedent was set up by Supreme Court itself, and when the Supreme Court accepted sealed cover and set a precedent, lower court will obviously subsequently follow. So this is something about this particular concept. I hope you understood about this particular issue. We'll come again soon with another interesting topic. Till then, take care. Thank you very much.